I'm going to get started. I'm State Representative Matt Smith, and I just want to thank everyone for coming out for another one of our Older and Wiser seminars. One of the things that I think I've always viewed is one of my responsibilities is putting together these events where we can, free of charge, to my constituents to get as much information in your hands as possible, so that you can make informed decisions about whatever the particular issue might be, whether it's Social Security, whether it's Medicare, whatever the issue might be, particularly for our area seniors, to make sure that you have the most convenient and available information at your fingertips. And that's what I've always strived to achieve over the last 5+ years. It really is a nice service that we can offer through Neighborhood Legal Services Association, because they send folks out, as I said, free of charge to provide this information to all of you. So I first want to thank Bethel Park for allowing us, for hosting this event in their council chambers, and obviously for Bethel Park TV, BPTV, for covering the program today. I think for those seniors who weren't able to make the program in person, they can watch on BPTV. It'll be on several times over the next few weeks as folks are just sort of flipping through their channels. Hopefully they'll find this, and we'll be able to provide the useful information that we can provide as part of today's event. I also want to thank Joe Olympi, who's typically here from Neighborhood Legal Services Association. He puts it together. Leo Bowers for coordinating today's presentation, and our attorney that we brought with us here, Mario Santilli, who will be providing all of the useful information and answering certainly any questions you may have on the particular topic. And we've held a lot of these Older and Wiser seminars over the last few years, as I said, to provide you with information. Today's, as you know, will be on last wills and living trusts, which is a very important issue, and there are a lot of misconceptions out there. And Mario has done these seminars, knows the issue like the back of his hand, and will certainly be able to provide you with any information that you need. And I want to make sure before we get started here, I know we have a local elected official and dignitary in the audience. I want to just thank Mayor Cliff Morton for coming to today's event, and Mrs. Morton accompanied him. Thank you very much, Mrs. Morton, for joining us here today. And that's really what we find in Bethel Park. As many of you know, I was born and raised here, and just that sort of local commitment that we have from our elected officials is always very meaningful, whether it's on senior issues, veterans issues, whatever it might be. The last thing I want to bring up in my introduction is please feel free to help yourself to refreshments. We have brochures in the back of the room, obviously specifically focused on senior-related issues. And the one thing I want to make sure everyone's aware of, we're going to be doing another one of our shredding events, and very happy to be joined by the municipality of Bethel Park on this as well. Another one of our free shredding events on Saturday, August 18th. It's coming up in about a month, from 10 a.m. to 1 p.m. right up the road at Independence Middle School, right in the parking lot as you wind down the parking lot, or wind down the driveway at Independence Middle School, right where the school is physically located. It's a free shredding event. If you have documents like Social Security information you want to dispose of properly, checking account records, canceled checks, credit card statements, whatever it might be, it's a great way to ensure that your personal information is being disposed of properly. You can actually watch the paper be shredded right in front of you, just to give you an additional comfort level. So it's another free service that we offer. Again, it's Saturday, August 18th from 10 a.m. to 1 p.m. over at Independence Middle School. And again, a very valuable service that I think is the least we can do in offering to folks to make sure that you know that your personal information is being destroyed properly. You certainly don't want to get into an issue. We've done some seminars on identity theft, which can be a tremendous problem. So you want to make sure that personal information is being disposed of properly. So without further ado, I want to bring up our experts here to the mic who can answer your questions and give you this valuable information. I want to bring up Leo Bowers from Neighborhood Legal Services Association to introduce Mario Santilli, who's going to be the real expert on this issue. So thank you again for coming. I really appreciate it.
Yes, I'm a staff attorney with Neighborhood Legal Services. I want to thank Representative Matt Smith for making this possible. It really doesn't happen without him. I'm not going to take up a lot of your time. I just want to point out that we do have these handouts. Please fill them out. We take this information seriously to continue to improve these programs. And we do have some sponsors as well. And I'll just click through these. I'm not going to take up a lot of your time. And then I would just like to ask Mr. Santilli to come and thank him for coming.
Thank you. Thank you. Good afternoon. And hopefully the rain holds off a little bit. It looks pretty threatening out there. And I hope when somebody's paging through the channels next week that I don't scare them when they pass by my face on the TV screen. Our topic today is about wills and living trusts. And I know that each of you have received solicitations in the mail, telephone calls, have heard or saw TV shows, have heard radio programs, all talking about this idea of living trusts and wills and their use in estate planning. By a show of hands, within the past maybe 5 years, how many of you have updated your wills or your estate plans? Okay. Okay. And a number of you have suggested that you have, and that's a good thing to do, and to periodically review your estate plan to make sure that what is in your documents comports with what you would like to have happen to your estate when you pass away. One of the most important things that we need to understand is the will or the living trust is just one aspect of how we transfer wealth when we pass away. Let's start off with a little comic strip. And many of you may be familiar with the Dilbert comic strip. And one day this appeared in the Post-Gazette, and it's titled, ironically, Estate Planning. And the lawyer says to Dilbert, "You can avoid probate costs by creating a living trust." And Dilbert, after thinking about it, says, "So I can use an inconvenient system created by lawyers to avoid a worse system created by lawyers." And the lawyer says, "According to my watch, that witty observation cost you $4. One of the things that we want to point out here is that there are pros and cons to whether you've got an estate using a will or an estate using a living trust. There isn't a philosophy of one is better than the other. I've done this for 31 years. I have planned estates with wills, and I have planned estates with living trust as the cornerstone of that estate plan. It is something that is, the decision to use one versus the other is something that you decide, that the lawyer decides in consultation with the client what meets that client's needs best. When you see some of these solicitations that come to you, whether it's in the mail or on the radio, you'll notice that they're already touting the benefits of a living trust. By definition, then, they are biased to choosing a living trust as the centerpiece of an estate plan. And that may or may not be appropriate for you. And we hope by what we present here today to at least give you some information to ask your lawyer or ask that person that you meet with. And one of the things that I'll repeat many times today is if you do receive one of those solicitations or invitations to meet with somebody about a living trust, please ask that person if they are a lawyer. Oftentimes, that person you meet is not a lawyer. Ask that person if they have a permanent office here in the Pittsburgh area. Ask them where their home office is. Ask them if you will ever meet with a lawyer. Because oftentimes these programs are presented not by lawyers, but they're presented by somebody who labels themselves either a financial planner or an estate planner, and they are not lawyers. There are three main ways, and I mentioned earlier that there are a number of ways to pass property when you pass away. And there are three main ways to pass property when you pass away. The first and foremost is the title of an asset. For example, you have a joint bank account, a husband and wife bank account. Automatically, at the death of the first spouse, the surviving spouse inherits the balance of the account. Doesn't matter what the will says, what governs in that instance is the title of the bank account. Similarly, you may very well have gotten some friendly advice from a teller at the bank or some friends or neighbors that say, you're getting older, your husband or your wife had passed away, you need somebody to pay your bills, you should add your child's name to that account. What you've done by adding your child's name to that account is make that child the beneficiary of that account when you pass away, to the exclusion of your other children, even if your will says, divide my estate among all my children. So the thing you want to do, instead of adding a person's name to a bank account as a joint owner, unless you just have one child, or you want that child to have something extra because they're paying your bills, but the thing you want to do is to use the power of attorney. And we'll be talking about all the documents that consists of a good estate plan, regardless of whether you use a will or you use a living trust as the centerpiece of your estate plan. Now I want to back up a second and tell you one thing. There isn't anything or any tax savings that results from a living trust, using a living trust, that cannot be achieved by using a will. I can accomplish the same tax savings and tax planning using a will as I can by using a living trust. There's no difference tax-wise. And when I say tax-wise, I'm talking about inheritance or federal estate tax. Now, the second way to pass property when you pass away is by virtue of a beneficiary designation. And the assets that you most commonly think about with a beneficiary designation are life insurance, IRAs, 401k plans. Those things have a beneficiary designation. And again, ignoring what the will says, who you've designated as the beneficiary on a beneficiary designation is who's legally entitled to that account when you pass. Now, there might be moral issues aside. I really intended my children to use this money to pay for my funeral. I really intended my child to share this with his or her siblings. This is one of those areas where moral obligations can't be enforced. The legal obligation is that who's ever designated the beneficiary of that account isn't legally entitled to that account. Now, the last way the property will pass at your death, which is the safety net kind of thing, is either the will, a testamentary surrogate like a living trust, or the intestacy statutes. So again, in order of priority, you first look at the title, and you ignore whatever it says in the will. The second way is the beneficiary designation. And again, you ignore whatever it says in the will. And lastly, the will or the testamentary, the living trust or the intestacy statutes. When you do estate planning with a lawyer, the lawyer should make sure that the titling of your assets and the beneficiary designations on your assets are consistent with and not different from the content of your will or your living trust. So when a lawyer is doing this, he should be asking for change of beneficiary forms. Another place where we've gotten, quote unquote, caught up with beneficiary designations is several years ago, Pennsylvania adopted transfer on death registrations, where you can add a TOD designee to a bank account, a brokerage account, a stock, a bond. Again, the rush to avoid probate, then people that would designate somebody as the beneficiary on a transfer on death registration. And again, if it's not the same as who your heirs are under the will, that person doesn't have a legal obligation to share. And I'm not saying this to scare anybody. I'm just trying to inform you of how the different things, how these different aspects interplay in terms of transferring your wealth when you pass. One of the things you want to make sure is as much of, if not all of your money gets to your heirs as opposed to me, for example, or another lawyer, because then your children are fighting over who was supposed to inherit what, and court battles cost money. So let's talk a little bit about living wills, last wills. Who can make a will? A person who is 18 years old and of sound mind, a person who is under 18 cannot make a will, and a person who has been adjudicated by a court to be incapacitated or incompetent cannot make a will. Now, if a court hasn't declared somebody an incapacitated person, that will, and someone tried to take advantage and got that person to sign a will, that would be something that would need to be contested after the fact. But if there's an adjudication of incapacity by a court, then an incapacitated person cannot make a will. Why do you make a will? And estate planning, whether you're using a living trust or whether you're using a will, is a process of gaining control. Gaining control of who gets your estate, when they receive it, who settles your affairs, who's the executor. If you have minor children or minor grandchildren who are going to benefit, you set the parameters for how they're going to inherit and who's going to be in charge of those monies for them, and include whether it be a trustee or just a guardian. So it is a process of designating your beneficiaries, who's in control of collecting your assets, paying your bills, and distributing the funds. And if you have trusts that you're going to set up in a will or minors that you're going to benefit, it is where you would also designate the people who you want to be in control after the fact for those items. As I mentioned earlier, when you do an estate plan, no matter which kind of estate plan you use, one that uses a trust or one that uses a will, part of that estate plan should be a durable financial power of attorney. Oftentimes I hear the question, I've designated so-and-so to be my executor, or mom designated me to be her executor. She's now suffered a stroke. She can't pay her bills. Can I pay her bills? I'm the executor. Well, an executor doesn't become empowered to act unless the person who made the will died. So an executor only acts after death and once they've been appointed by the Register of Wills. So who can act for a person when they become mentally challenged or disabled? Well, then that's going to be what's called a durable financial power of attorney. It's designating somebody to act as your agent while you are alive but unable to transact your affairs. And it's a pretty powerful document. It's a document that's intended to replace the need to go to court to have somebody declared incapacitated. It's a document that empowers that person to do whatever you can do financially except make a will. So it is a very powerful document. In the wrong hands, it is a very dangerous document. One of our orphans court judges astutely observed that if Jesse James knew about powers of attorney, Jesse James would not have been robbing banks. How does somebody become an executor? First of all, you must be named in a will. You're the person who the testator, that's the legal term for the person who makes a will, must appoint you to be the executor or designate you as the person they would like the Register of Wills to empower to act as executor. If there is no will, the surviving spouse or closest next of kin are the people who have the right under Pennsylvania state law to administer the estate. How is an executor authorized to act? You have to go down to the Register of Wills, get sworn in, and you'll get what's called short certificates. So if any of you have ever had to serve in that kind of capacity and you've been asked, where's your short certificate? That certificate is the court certificate that designates you as the executor and tells the world that you have the authority to act. What is admitting a will to probate? Admitting a will to probate in Pennsylvania is a much less cumbersome process than it is in other places. In Pennsylvania, we complete a petition for adjudication that will enable the Register of Wills to have the original will, the address of the decedent, a token estimate of what the assets are involved, and who is the executor, and that executor's address. And then you get sworn in, and in some instances you must post bond. When might you post bond? Well, if you're an out-of-state person administering a Pennsylvania estate and there is no will, you may be required to post bond. In some very rare instances, somebody has drafted a will that says, I require my executor to post bond. One of the things that an executor must first do as soon as the will is admitted to probate is then send a notice, including a copy of the will, to each heir under the will saying, A, I've had to submit a will for probate, I've been granted letters of administration, here's a copy of the will, and you are an heir. What's the job of an executor? Well, the job of an executor is to identify and collect all of the assets that a decedent owned, identify and pay all of the bills that the decedent incurred, wrapping up all of the decedent's financial affairs, pay all the taxes that are associated, whether it's inheritance tax, federal estate tax, any income taxes that still need to be paid, file the last income tax return if there happens to be a gift tax return because the decedent made some gifts in the year of death. Those would be some of the tax returns that an executor must file. And then once all of the tax clearances are received and all of the bills are paid and you have a pot of money that's left over, the job of the executor is to distribute the balance to the heirs in accordance with the terms of the will or whatever governing instrument or Pennsylvania statute applies. Oftentimes people say, where can I find a person's will? So-and-so died. I think I'm named the executor or I have a copy of it. Where can I find the will? One place to start is with the lawyer who drafted it. Oftentimes we keep a copy of or keep the original because our client has told us they don't have a safe deposit box or they would feel safer that it was in storage in our vault. If the decedent had a safe deposit box or a safe or something like that at his or her house, that would be another place to look at for the location of the will. Anywhere where a decedent might have kept important papers. You need the original. That's an important aspect. If you could only locate a copy and the lawyer has records that say, I gave the decedent the original when he or she signed his or her will, then there's a presumption that the decedent destroyed the will and you would be administering an intestate estate, not a testate estate. Unless you can prove some circumstance like the house burnt down or there was a flood or something of that nature, extraneous that might have caused the destruction of the will and the decedent wasn't necessarily aware that that's what happened. But the presumption otherwise is that if you can't locate the original will, that the decedent revoked it. And the reason the courts do things like that is the person who can tell us what happened to their will or what do they like to have happen to their estate can't take the witness stand and tell us anymore. So we have to try to protect everybody's interests, or the decedent's interests in particular, in honoring what we have a record of is that person's last will. And if we don't have a last will, then we resort to the Pennsylvania statutes. Whether or not it's a jaded approach, the suspicion of everybody has their own interests at heart, and they would say, oh, Mom told me that I was supposed to get $100,000 off the top, and then everybody else can divide things equally. You could get any number of arguments. In fact, you can even get an argument that says everything was supposed to be divided equally. That's what Mom told me was supposed to happen. But after you poke around a little bit, you find out that that person telling you that had borrowed a lot of money from Mom and never paid Mom back, and so her Mom's will was maybe unequal to equalize after the fact. One thing about Pennsylvania, though, is that you don't register a will when somebody signs it. There's no copy put at the Register of Wills while you're alive in Pennsylvania. Some other states do use their clerk of courts or their equivalent of the Register of Wills as a repository for wills, but not Pennsylvania. The only wills you'll find in the Register of Wills office are for dead people. What is a durable power of attorney, financial power of attorney? It is a document where you appoint somebody to act on your behalf while you're alive and unable to transact your affairs. You can grant as many or as few powers, as you choose in this power of attorney. For example, I have drafted powers of attorney that just enabled someone to go to a closing and sign documents at a real estate closing. My typical powers of attorney are drafted very broadly that suggests that the agent empowers the agent to do anything that I could do financially, again, except make a will. And then I do import provisions into my powers of attorney that enables an agent, under certain circumstances, to petition to court to modify a will. And those circumstances generally deal with tax planning, federal estate tax planning, or medical assistance type of planning. Granting the broadest possible authority, like I've just described, is designed to eliminate the need for the family to seek a guardian to act on your behalf. Granting the broadest authority is generally the choice that people use, but again, you also want to make sure that you're designating the person or persons whom you trust. You can, in Pennsylvania, designate multiple agents. You can designate agents who must act either jointly with each other, or even if you designated multiple agents, that they can act independently. The most important thing for you is to know that you've empowered somebody to pay your bills. That's what people mostly are concerned about with respect to a financial power of attorney. How can I empower somebody to pay my bills? It is the choice to use rather than adding somebody's name to the account. What they can do at the bank, though, is the bank has its own signature cards that are power of attorney signature cards. Is once you do that, they can in fact fill out one of those cards when necessary to become your agent, and that there would not be any problem at the bank with them signing the checks with the word agent after their name, as opposed to just their name because they're on the account. And I'm sure many of you have read in the paper over the last several years of a number of instances where there's been abuses of powers of attorney. As I mentioned, one of our local judges astutely observed that if Jesse James knew about durable financial powers of attorney, he would never have been robbing banks. I've said it once before, and again, to drive home the point, Can I just add my child's name to the bank account to pay my bills? No. If your child, and here's one good reason, if your child died before you, you would pay Pennsylvania inheritance tax on your own money. And I had that instance just recently. I had a fellow who died on May 27th of this year. And he had a number of bank accounts. His wife had died several years ago. He had a number of bank accounts with a local institution, and they were very friendly with him. He was very friendly with them. They all waited for him to come in, and they thought they were being very helpful. And when his wife passed away, they asked him to he said, you should put your son's name on the accounts. Now, my client didn't tell me this. We had revised his estate plan. The money for the son was supposed to be going into a trust because my client didn't like his daughter-in-law and thought the daughter-in-law was going to leave his son as soon as my client died. So, but he listened to the branch manager at this particular bank, added the son to the account. On March 28th of this year, his son committed suicide because he was in the middle of a divorce with the daughter. So when I get the list of accounts, I see that it had the son's name on it, and we ended up having to pay $8,000 of Pennsylvania inheritance tax on half of the value of the assets, and then 2 months later had to pay inheritance tax on the entire value of the assets. So in this unfortunate event, in a span of 2 months, I paid inheritance tax on 150% of the value of those accounts. Another reason you don't want to put your child's name on it is your child's share, quote unquote, of the account is subject to the claims of his or her creditors. If they, God forbid, got into an automobile accident or in a bankruptcy or something of that nature, a divorce, there can be a claim against the half of the account because his or her name was on it. And lastly, the thing that I've harped on the most is after you die, that child is under no legal obligation to share what's in that account with his or her siblings, no matter what the will or trust says. Let's talk about living trusts for a second. What's a living trust? It's a written agreement that is either revocable or irrevocable, but the kind that normally is sold as a quote-unquote living trust is a revocable trust, meaning you can change it at any time, just like you can change a will at any time. The trust names the trustee. Typically, when we're doing a revocable trust, we're going to name you as the trustee. It's a document that requires a transfer of assets to the trustee. What does that mean? That means after you sign your trust, you have to go and retitle each and every one of the assets to have your name, assuming you're the trustee, with the word trustee after it. That's how it's quote-unquote titled. So remember going back to that first slide where I said there was 3 ways to transfer property. The first one was titling. The second one was a beneficiary designation. The last was a will or a will substitute. Well, the titling then becomes not Joe Smith, but Joe Smith trustee to indicate that this is now a trust asset. It's owned by a trustee subject to the terms of this trust. And any asset that does not get re-registered that way, then there's still a will that would be done. It's called a pour-over will. And the will would contain a provision that says, by the way, any asset of mine that did not get retitled into the name of my trust shall pass through my estate and be poured into and added to the trust created on whatever such and such date, the revocable trust. It contains directions regarding the management of your assets both at life and at death. So there is one difference between a will and a living trust. A will controls assets only after you pass away. A living trust, on the other hand, and a trustee, on the other hand, has authority to act on those assets both while you are alive and after you pass away. Who can make a living trust? The same requirements as a will. A person who is at least 18 years old and of sound mind, just like a will. A person who is declared incapacitated or by a court cannot make or change a living trust. Who can serve as a trustee? If we're dealing with a revocable trust, you can serve as the trustee of the trust that you create. But generally, for federal tax reasons, you can't serve as the trustee of an irrevocable trust you create. When you're creating an irrevocable trust, you're using some gifting techniques and some strategies under the Internal Revenue Code to eliminate or remove that asset from your estate. Maybe some of you have an irrevocable life insurance trust. That would be one of the most common examples. And you can't be the trustee of your own irrevocable life insurance trust because that means you can still control the beneficiary and can still control the policy. And that's what you're trying to get rid of and remove from, so that you can remove that asset from being counted as part of your federal taxable estate for federal estate tax purposes. Who else can serve as a trustee? Well, any competent adult. You can name a son, you can name your accountant, you can name anybody you have a relationship with that you trust. You can name a bank which has trust powers or a trust company. If you were to name a corporate fiduciary, they charge an annual fee, and usually it's somewhere between 100 basis points to 125 basis points annually. What does a trustee do? Much like you do, the trustee manages your assets. And once you transfer assets to your trust, only the trustee has the authority to act with respect to those assets. Living trust versus durable financial powers of attorney. Does a trustee other than me have the authority to take care of my property if I become mentally disabled or incapacitated? The trustee of a revocable trust or the trustee of an irrevocable trust has authority to transact affairs for those assets that have been transferred to the trust, regardless of whether you're mentally capable or not mentally capable. If you were the trustee of your own revocable trust and you become mentally incapable, there would be an alternate designated to take your place and act on your behalf. What a trustee can't act on, though, are assets that don't get transferred to the living trust. And what are some of those assets that commonly don't? An IRA or a 401k plan, for example, would not get transferred into a living trust. That would be tantamount to withdrawing all of your IRA or all of your 401k and have horrendous income tax consequences if you tried to retitle your IRA or your 401k into your living trust. So you still would need a durable financial power of attorney because there are assets or are circumstances or applications, for example, for Social Security benefits, medical assistance benefits, signing tax returns that a trustee can't do on your behalf. So as part of an estate plan that uses a living trust, you still would need a durable financial power of attorney. So let me take a step back and then say, okay, then what documents should be part of an estate plan? Well, if you're using a will-based estate plan, you should have a will, you should have a durable financial power of attorney, you should have a durable health care power of attorney, you should have a living will, and we also do HIPAA authorizations because we've come across this circumstance where when dealing with an agent under a power of attorney, somebody doesn't want to give medical information out. If you're using a living trust as the corner piece of your estate plan, you're going to still have a will, you're going to have a living trust, you're going to have durable financial power of attorney, you're going to have a durable health care power of attorney, a living will, and again, we do also the HIPAA authorization. What are revocable and irrevocable trusts? Simply the difference between the normal meaning. A revocable trust can be changed. You can add or remove assets. You can change the beneficiaries. You can terminate or amend the trust. An irrevocable trust cannot be changed once you establish it. So You have to think long and hard and have the benefit of good counsel before you establish an irrevocable trust. You usually create an irrevocable trust for some kind of federal income or estate tax purpose. For example, life insurance proceeds can be excluded by transferring a life insurance policy to an irrevocable life insurance trust. You're not the trustee of that trust, and you live 3 years after that policy is transferred to that trust. Why establish a living trust? Much like when I talked earlier about why do a will, you establish a living trust to designate who your beneficiaries are, when your beneficiaries will receive your property, who is in charge of settling your affairs, and to avoid probate in multiple states because you own real estate in more than one state. So this last reason is one of the things that I focus on when I'm trying to decide whether or not to use a will or a living trust for the cornerstone of an estate plan for one of my clients. Which is best for me? Excuse me. The question is, which is best for you, not which is best for the person selling it to you. What should you consider? The size of your estate, the types of assets, and for you, which is the most overall cost-effective vehicle? What costs are involved? Well, the first thing that people are going to say is cost up front to prepare the document. Typically, it's more expensive to prepare an estate plan using a living trust than it costs to prepare an estate plan using a will. And the reason being is, aside from beneficiary designations and making sure things are titled correctly, my time involved would be the cost of drafting the will and the powers of attorney. If I'm dealing with a living trust, I've got the added layer of making sure that we have retitled all of the assets to your living trust, because if I just send you off with your documents and don't help you retitle the assets, oftentimes the assets don't get retitled, and in which case you're still stuck with a probate for the entire extent of your estate. And you haven't done any useful purpose other than creating an additional step when you pass away. On the back side of things, when you pass away, what's the difference? You often see these solicitations for living trusts say, we need to avoid a shrinkage of your estate, or I can save you this in tax, or I can save you this in probate costs, and I can save you this in lawyer's fees. Well, first off, the trustee of your estate, of your living trust, has to do the same things that the executor has to do. Collect all your assets, pay all your bills, file all the tax returns. They're going to need a lawyer to do the same things. Myself, my contemporaries in town, those practitioners I view as my contemporaries in town, we generally charge estate administrations on an hourly basis, not a percent basis. So whether we're doing an estate administration using an estate or using a living trust, we're going to have the same thing. Did I do something? No. We're going to have approximately the same cost, because we're going to be dealing with creditor issues, we're going to be dealing with accounting issues, and we're going to prepare the inheritance and the estate tax. And so from that aspect, just isolating those two aspects, they're going to be the same. The difference may be that you're saving something from going to the Register of Wills. The filing fees in Allegheny County and in Pennsylvania in general aren't that onerous. The filing fees perhaps in New York and Ohio and California are another story. It's almost like another tax, so to speak, because they are kind of substantial. So again, part of the equation of trying to figure out, do I use a trust or do I use a will, is where do these people live? What kind of assets do they have? Where are their assets? Am I going to be required to do a probate in another jurisdiction? Choosing an unbiased and an experienced estate planning lawyer familiar with both wills and trusts is critical, because they're going to give you that analysis and say, this is what's best for you, as opposed to this is the way you should do it. As I mentioned, I've done this for 31 years, and I haven't put everybody in wills, and I haven't put everybody in living trusts. I have done both. I have done seminars on living trusts where I explain them and try to get new business in that regard. So it's not like I have a bias against living trusts. Don't want you to get that impression from what I'm talking about or how I'm presenting this seminar today. I'm just trying to give you the keys, so to speak, or the critical aspects that you should keep in mind when when someone approaches you about modifying your estate plan and using a living trust. As I mentioned, there can be significant cost differences. Generally, living trusts require more time up front, which means a higher cost to prepare. Generally, an estate planning using a will can range from $500 to $1,500, depending upon the level of complexity, the hourly fee of the lawyer preparing the document. And similarly, the cost of a plan using a living trust ranges from $2,500 to $3,500 because of the extra time involved in making sure those assets that need to be retitled are in fact retitled. A will must be probated, and the court filing fees, although fairly reasonable in Pennsylvania, do depend on the value of the estate. The most common misperception is avoiding probate doesn't mean you avoid estate and inheritance taxes. Both the Federal Estate Tax Code and the Pennsylvania Inheritance Tax Code are written so that if it's an asset in which you have an interest, whether it passes by probate or passes by revocable trust or passes because of titling, is going to be subject to Pennsylvania inheritance tax with certain exceptions. Proper planning means you can achieve the same tax result no matter which vehicle was used, a will or a living trust. 2012, I probably should have updated this slide. In 2011, the federal exemption is $5 million. To 2012, I prepared this at a time when I didn't know what the index for inflation was going to do. The exemption for federal estate tax this year is $5,120,000. The tax rate for the federal estate tax rate is 35%, and it's on those assets above the $5,120,000. Assets in a revocable trust are subject to tax. Okay, let me backtrack because this is a critical aspect here, and it's going to change. And you're going to be, in fact, you're going to be seeing something in the newspaper tomorrow probably on it. 2011, the federal estate tax exemption is $5 million. 2012, the federal estate tax exemption is $5,120,000. So for federal estate tax purposes, you have to have $5,120,000 before you're worried about federal estate tax. And then the tax rate for those assets above $5,120,000 is 35%. Now, on December 31st of this year, that law expires. Beginning on January 1st of next year, the exemption is $1 million, and the tax rate is 55%. Tomorrow, Congress is supposed to, the Senate is supposed to vote on a bill regarding extensions. The Democrat, and I'm not trying to pick sides here, I'm just explaining who's giving the proposals. The Democratic proposal tomorrow being put forth would be $1 million and 55%, made permanent. On the other hand, the Republican proposal is $5,120,000 with a 35% tax rate. Tomorrow's proposal that's going to be voted on is different than the proposal President Obama had introduced to Congress 4 months ago. 4 months ago, President Obama had introduced a proposal to make it $3.5 million with a tax bracket of 45%. Where we're going to end up, we don't know. Do I think something's going to happen tomorrow? I don't think so. There's an election. Who's going to want to add fuel to the fire that now it's $1 million exemption, or who's going to want to take credit for passing a tax bill before November? I personally don't think anything is going to happen until next year. You might remember that several years ago, at the end of 2000, we went through a year, 2010, where for most of the year there quote-unquote wasn't a federal estate tax. In fact, George Steinbrenner was able to pass the New York Yankees free of federal estate tax because he just chose to die at the right time. At the end of the year, after the elections that year, Congress got together and voted and adopted this law that's in place right now, where the exemption for 2011 and 2012 was $5 million, $5,120,000 this year, indexed for inflation. But they also made the tax retroactive back to January 1st of 2010, but gave us a choice. We could pick which was better for us, and they did that to avoid the constitutionality argument of making a tax retroactive. For those that chose the estate tax to apply, you had an estate that was less than $5 million, and what you wanted was a step-up in basis for capital gains purposes. For those who didn't want the estate tax to apply, they didn't get a step-up in basis. So that was a one-year anomaly that might have some ripple effects in the future, but for the most part, we now have this law that's set to expire at the end of the year, and where that exemption is going to be is largely going to be determined by the composition of both houses of Congress and the President, probably next February or March. Pennsylvania, on the other hand, doesn't have an exemption. $1 is taxed, and $1 is taxed based on your relationship to the decedent. So if you were the decedent's spouse, what you inherit is taxed, but taxed at a 0% rate. If you had a joint account with your spouse, that's exempt. This would be, for example, an asset that was in an IRA, for example. Decedent has an IRA and designated the spouse as the beneficiary. The spouse then rolls over the IRA into his or her name. That's inheritance taxable and reportable transaction, but the tax rate is 0. If you were a child or other lineal descendant, grandchild or parent, up and down the line, lineals, a great-grandchild, stepchild, the tax rate is 4.5%. And again, no exemption, $1. If you're a sibling of the decedent, the tax rate is 12%. And if, in fact, you have no relationship to the decedent, the tax rate is 15%. As I mentioned, proper planning means you can achieve the same estate and inheritance tax result with a living trust or a will. Assets in irrevocable trust are subject to PA inheritance tax. They do not escape Pennsylvania inheritance tax. They do not escape federal estate tax if the trust is revocable. Annuities, contrary to the salesman's sales pitch, are subject to federal estate and Pennsylvania inheritance tax. They are. They are subject to Pennsylvania federal estate, Pennsylvania inheritance tax, and federal estate tax. And I know from talking to many of my clients that annuities are sold to them as not being subject to federal estate tax or Pennsylvania inheritance tax. Life insurance has different estate tax and inheritance tax treatment. It is subject to the federal estate tax if you own the policy or can control the beneficiary designation of it. It is not subject to Pennsylvania inheritance tax, regardless of whether it's payable to a person or to your estate. What's one of the differences between what assets are taxable for PA and federal purposes? Life insurance. Life insurance, yes for federal, no for PA. Another asset that has different tax treatment for PA and federal purposes are joint assets. Federal has the rule, look whose money it was in the account. It's 100, we presume it's 100% unless you can show contribution by the other owners. PA, on the other hand, says we don't have the time, effort, or money to go and try to track down and audit every estate and figure out whose money it was. If the account was made joint within a year of death, 100% is taxed. If the account was made joint more than a year before the date of death, then count up the number of owners, and the pro rata share of the decedent is what's subject to tax. So if there's 2 owners, it'd be half subject to tax. If there are 4 owners, only 25% would be subject to tax. What factors should an attorney consider when trying to decide whether to use a living trust or a will for you? One of the first things is, do you own property in other states? If you own property in other states, that means if you own it in your own name, that I would need to do a probate in each state in which you own property to ultimately get that property to your heirs. Each state jealously protects the property title to the real estate within its borders. So it won't, for example, Florida won't take a decree of distribution from a Pennsylvania court and say this is who's entitled to own the Florida property. Florida would want to do its own what's called an ancillary administration to change the title of that property from you to the name of your particular heir who's supposed to enjoy that property. So again, one factor arguing for using a living trust is that you own property in other states. Sometimes there's a need for centralized or professional management. What might that mean? Well, maybe you have everything in a brokerage account with several brokers. Or you have banks, various bank accounts in many different banks because you want to make sure that you don't run afoul of the insurance limits at any one bank. And now you're getting older and you're tired of looking at all the paperwork and you're tired of looking at all the statements that come in every month and you say, I want to consolidate. Well, one way to do that is you could be using a living trust and consolidating all those assets at a trust company, for example, where you're naming a corporate fiduciary and designating that professional person to manage your money instead of yourself. On the other hand, if you have a broker, you can accomplish the same thing using a well-respected financial advisor who's managing most of your assets in a single or couple of brokerage accounts. Again, that in and of itself isn't a factor to push it towards the living trust side because I can easily suggest an alternative for the other to use to accomplish the same objective using a will. The first thing that would switch it for me would be you own property in multiple states. The value of your estate. Value in and of itself, if you have a $5 million estate, doesn't tell me you have to use a living trust. Value could, in fact, in those jurisdictions that have high probate filing fees at their equivalent of the Register of Wills, or if you have a significant estate and you don't want to pay the fee that might result because it is that significant at the Register of Wills office, that might be a reason to use a living trust. But again, value in and of itself, from a tax-driven perspective, isn't a reason that I would use one versus the other, but it is something that you start to look at. What are the costs that are going to be involved that I can save in an estate or trust administration after the person passes away? Because again, if you start looking at it, what am I doing? I'm pushing the pencil to the paper and I'm trying to figure out how do I minimize all of the costs that are going to be involved for this family and maximize the wealth that goes to and stay within the family. What's the composition of your estate? And here's one of those things where the value of the estate belies using a living trust versus a will. You might have a $4 million home and $30,000 in other assets. Just because you have a little slightly more than a $4 million estate doesn't mean you need to use a living trust. And in fact, I wouldn't suggest using a living trust in an example where 70 or 80% of the value of your estate is either a retirement asset like an IRA that cannot go into a living trust, or a single asset like a home or a business, a closely held business that you may have. Lastly, privacy concerns. A number of people have privacy concerns, and that may dictate using a living trust. High-profile individuals, professional athletes, people who own a lot of municipal bonds issued by a government, the local government, just don't want people to know. Or they have an overarching privacy, any one of us has an overarching privacy concern, and we don't want people to know how much we had. Now, there is another misperception. Misperception is it's going to be in the newspaper how much I have if it goes to probate. What gets advertised when an executor is appointed is who was appointed, who do you contact if you have a claim against the estate. It does not include the value of the estate. If somebody wanted to know the value of your estate, they'd have to go to the Register of Wills office, have to request your file, and then look it up. Court files are open records. If there's a probate, somebody would need to actually go to the Register of Wills. Register of Wills will not fax somebody an inventory, will not give that information out over the phone. They're not allowed to. One size doesn't fit all. So the solicitations that say, see how a living trust can save you money, are already biased and are already going to try to put you into a living trust, regardless if that is the right thing for you or not. As I mentioned at the outset, often living trusts are sold by non-lawyers. Ask the salesperson if he or she is a licensed attorney in Pennsylvania. Ask the salesperson when you're going to meet a lawyer. Ask whether they have permanent offices in the area, and ask where their home office is located. More often than not, the people sending those solicitations that you get or invitations that you receive in the mail are not lawyers. Or they may have a lawyer putting on a presentation, and that's not the people who you then end up dealing with when you're meeting with someone to discuss your estate plan. Ask for specifics, why a living trust is more appropriate for you. Don't accept we're going to save you taxes. Don't accept we're going to avoid probate costs. We're going to minimize shrinkage. Ask for specific reasons why a living trust is the more appropriate vehicle for you. Can these help me decide? Susie Orman, a TV show, you read a book or an internet article, you heard a radio commercial, you attended a living trust seminar, you responded to a phone, mail, or door-to-door solicitation. No. Those are already biased, and they're always written in a general kind of way, not addressing your specific format. They don't take into account your specific circumstances. Most are not geared to Pennsylvania or don't address Pennsylvania-specific laws. They're biased. They're already designed to sell you the living trust. In general, a married couple with a modest home and modest savings should not need a living trust. Conversely, individuals owning real estate in several states should consider a living trust. Myths of estate planning. Living trusts avoid probate. That's one of the things you're going to see on their solicitations. Well, it implies that you've transferred all your assets to the trust. If you didn't do that job, you still have a probate. Probate should be avoided because it's costly or it causes delays. Picture yourself as the trustee of a trust, your mother or father's trust, and you now have to distribute the assets to your siblings. Are you going to distribute the money in that trust before you've paid all the bills? How difficult will it be to get money back if a creditor surfaces? The point of that is that an executor and a trustee have the same duties and responsibilities. Collect all the assets, pay all the bills, distribute what's left over when you know there's no more claims. So there's going to be some delay between the time somebody passes to the time money can be distributed based on, did I have to sell a house? Did I have to clean out the house? Did I have to market the house? Were there a lot of bills that needed to be paid? Was mom or dad sick for a while? And the insurance thing, you keep getting all of these bills all the time, and we don't know what we're going to end up having to pay and what we're not going to have to pay. And lastly, do we have a federal estate tax return and a Pennsylvania inheritance tax return? Because each of those returns are examined. With the Pennsylvania inheritance tax return, you have to wait for the slip from Pennsylvania that says either accepted as filed or here are the changes or their list of questions wanting clarification on certain assets. Federal estate tax returns, on the other hand, all get filed in Cincinnati. They're reviewed on some level. Each return is reviewed on some level. Either it's looked at and just accepted right off the bat, or it's then assigned to an examiner. Whether it's assigned to an examiner who does a little bit closer check and then issues a closing letter, or it's assigned to an examiner who sends a letter to the lawyer for the estate saying, I need further clarification, it remains to be seen. But again, an executor is not going to pay out any assets. A trustee of a living trust is not going to pay out any assets until they know they've paid the tax bill, because they're going to be personally responsible. Properly drafted and funded trusts still may not avoid probate as to the assets that didn't get to the trust. And there's always some refund or something that doesn't get into the trust. Just because by definition you might have an income tax refund. You might have refunds that are due from a long-term care insurance policy or health insurance policy or some other premium that you've paid that your estate would be refunded. So by definition, there is always some asset, no matter how insignificant, that is not in the estate and may require a probate to negotiate that check. Often assets are never retitled, and again, going back to who's going to help you with your retitling once you create a living trust, a lot of times those people who are selling, quote unquote, the living trusts, who are not the lawyers, you don't see them after you sign the document. They don't help you with the asset re-registration. So another question you can ask, who is going to help me retitle my assets? If a dispute arises among your beneficiaries, regardless of whether you use a trust or a living will, a will or a living trust, you're going to have to record the trust. The trust is going to become a public document, and the privacy, if that's what you were seeking to achieve, would not then be the benefit you would receive. What is probate? In Pennsylvania, the probate court is a section of the court that supervises the administration of estates and trusts. In Pennsylvania, it's a rather passive than active supervision. We don't have to go to court to get sworn in, like in New York, for example. They have a hearing on whether to admit the will. They have a hearing on whether this person should be appointed. In Pennsylvania, you walk in with the will, with the appropriate pleadings, you get sworn in, you become the executor. Then it's an act. If somebody's going to contest the will, on the other hand, that's when the court becomes active. But in the first instance, it's rather passive. It's the duties and the responsibilities are on the executors to file whatever papers are necessary, like an inventory, like an accounting, like the tax returns. In Allegheny County, the probate fees are rather insignificant. A 15-page will costs $75 to file. A $1 million inventory costs slightly under $1,300 to file, and a $1 million account costs about $650 to file. I understand that the filing fees are supposed to go up in the near future, but that's what the filing fees are right now for a $1 million estate. Probate is a form in which a creditor can make a claim. And a creditor can make a claim in the probate courts whether you have an executor or, in fact, you have a trustee. A trustee is required, if everything got titled in a living trust, a trustee under the Pennsylvania Uniform Trust Act is required to advertise who the trustee is and who you contact if you're a creditor making a claim. Absent a trustee doing that, absent an executor advertising that, they may never know if there's a claim that exists. There's never a statute of limitations that runs and bars that creditor's claim. So one could come out of the woodwork several years later because there wasn't an advertisement. Probate in and of itself doesn't delay distribution. Both executors and trustees must pay the decedent's outstanding debts, expenses, and death taxes before distribution can safely be made. That's not to say that the executor or trustee has to hold on to every dollar of the estate administration until the very end. At some point in time, after taxes are paid, an executor or a trustee can get together with the attorney and decide what's a safe cushion to leave, what do we expect we might see, and then make an interim distribution before a final distribution can be made. Does probate delay distributing an estate? No, the time it takes to complete an estate or living trust administration depends on a number of factors. The complexity of a decedent's financial affairs, how quickly you can liquidate all the assets. Real estate and businesses sometimes are the most troublesome and problematic assets. Is there litigation? Are there creditors? Are there will challenges? Is the estate subject to federal estate tax law? How long does it take to identify all the co-payments and insurance coverage and get the last bills from the hospital? How long does probate take? Absent litigation, the process is controlled by the executor or the trustee. They won't make distributions again until they're fairly certain of what their obligations may be. The IRS and the Department of Revenue audits all estate and inheritance tax returns. Other than probate and inventory fees, there's little to distinguish the relative cost in administering an estate using a will or a comparable sized estate using a living trust. Living trust save taxes implies that you can only save these taxes using a living trust. And as I said earlier, there isn't anything that you can, tax savings that you can achieve using a living trust that you cannot achieve using a will. I can accomplish the same tax savings either way. How is that possible? Well, what they're talking about is that in the living trust, when you have a husband-wife circumstance, you create a trust for the benefit of the surviving spouse. Upon the death of the first spouse, some of the assets go into the trust for the surviving spouse, as opposed to in the surviving spouse's pocket. The difference being, if it's in the trust with certain parameters, under the Internal Revenue Code, those parameters are such that it's not considered the surviving spouse's money. Now, what kind of rights are typically assigned to a surviving spouse? Usually the surviving spouse gets all of the interest and dividends. Usually the surviving spouse can be the trustee. Usually the surviving spouse can get the principal for health maintenance and support. The only difference is it's just not in your pocket. You don't have unfettered control. You have to file a separate tax return for it. Non-probate assets like IRAs, joint bank accounts, annuities, life insurance policies, and 401ks all avoid probate. They're non-probate assets. They're still subject to federal estate tax and inheritance tax. What's subject to federal estate tax and Pennsylvania inheritance tax again briefly? Assets that are in your own name or owned jointly with another. Assets in a living or revocable trust. IRAs, 401ks, and annuities. Life insurance is subject to federal estate tax, but not Pennsylvania inheritance tax. Sales for $1 are not legitimate sales. They're a gift. And it would have required a gift tax return to be filed in the year that sale occurred. But more importantly, if you continue to live in that house that you sold for $1 to your child, you've retained a life estate. And Section 2036 of the Internal Revenue Code and Section 9111 of the Pennsylvania Inheritance Tax Code would subject that asset completely to inheritance tax. The downside is that there would be no step-up in basis to the child who inherited that property, even though the inheritance tax or estate tax was paid. Federal gift tax does not apply to assets in a living trust. It applies to assets in an irrevocable trust. Living trusts are private. Myth number 3. They would be private as long as there's no trust contest, dispute among the beneficiaries, something of that nature. Once that occurs, the document must be recorded so that the court knows what it's supposed to be interpreting or what's supposed to be governing this dispute. Register of Wills files are public records, but the curious need to go to the court to review the file, and generally wills are not online yet in Pennsylvania. The public advertisement of executor's appointment serves as a notice that who a creditor should contact, not the amount of the estate or the value of the estate. In either case, advertisement does not include the gross estate. And we've talked about, again, if a dispute arises among the beneficiaries, an accounting would need to be filed if they're challenging the action of the trustee or the executor. And when a trustee must prove his or her authority, he or she frequently distributes a trust. That's another way that a trust could become public. Living trusts save fees. Generally, it's more expensive to prepare a living trust than a will. Trustees, like executors, are entitled to compensation. It all depends on the trustee or the executor, if they're a family member, if they're going to charge compensation. Compensation is income taxable to the trustee or executor, and that's one reason why an executor may or may not charge a fee. Attorneys still have to prepare the same estate, income, and inheritance tax returns, oversee disbursements, and prepare accountings. So roughly, attorneys' fees are going to be the same regardless of which was used. Used to be that people would say it's more difficult to contest a living trust than a will. That's not the case. The standard in Pennsylvania is identical for whether you're going to contest a living trust or a will. And that is that the testator had to have capacity, had to know the nature and extent of his or her estate and the natural objects of his or her bounty. It is a very difficult burden of proof to be successful in a will or trust contest because, again, the person whose will or trust it is can't take the witness stand. So the courts have set a high bar of a burden of proof of clear and convincing evidence to overturn a will or a trust. Statistics show that about only 18% of will or trust contests are successful. The biggest difference is the statute of limitations to contest a will versus a living trust. The will gets admitted to probate, then we have the advertisement. The time to contest a will is 1 year from the date the letters of administration or letters testamentary are granted. 1 year from the date you go to the court. With a living trust, if you don't have to go to court for some reason, then when does the period start? The period doesn't start until a lawyer sends a notice to all of the beneficiaries and possible beneficiaries who might contest. And then it's 1 year from the date that notice was sent. So, problem is, oftentimes people don't overlook that step and don't send a notice in the living trust administration context, and then you have an open-ended, the year statute of limitations never ran or hadn't begun to run. So one of the things, if you're involved in a trust administration using a living trust, is to make sure the attorney handling the affairs sends out the requisite notice to all of the beneficiaries. What should you do to prepare for estate planning? Make an inventory of all your assets, including names on the account. That's a big important thing. More important than maybe even the value is, how are your assets titled? If you have a beneficiary designation on an asset, attached to an asset, who are the beneficiaries, both primary and contingent? Locate your will, your durable financial power of attorney, your durable health care, living will, other important financial information. Sometimes the lawyers like to see the old documents, sometimes they don't. How could you do estate planning, or what should you do next? You consult with an estate planning attorney who's qualified, understands you and your circumstances, knows Pennsylvania law. How would you locate such an attorney? Well, you can contact your own general attorney, see if he does estate planning, or ask him for recommendations. You can call the local bar association. You can ask friends or professional acquaintances for a recommendation. Sometimes internet searches are of value in this case. You'd be looking for somebody who was a member of the American College of Trust and Estate Council. You could Google Pittsburgh estate planning attorneys to find 4- to 5-star rated attorneys. You consult Yellow Pages. Periodically, you see those magazines come out where they name super lawyers, Pennsylvania super lawyers. They're all in various categories. But the most important place you could go is to your friends and your family members who have had estate planning done for them, and ask them for their recommendation, both good and bad, of who they, if they've used somebody, or if a friend or acquaintance has used someone. There are reduced fee referrals through the Allegheny County Lawyer Referral Services. Most of you may have seen, some of you may have picked up this pamphlet that was put together, Allegheny County Bar Association, The Truth About Probate and Living Trust in Pennsylvania. It was put together, again, by a group of lawyers in Allegheny County, meant to highlight some of the things that I've talked about here today, so that you can make an informed decision when you're meeting with somebody about your estate planning needs. Free of charge referrals from neighborhood legal services, income eligible residents of Allegheny, Beaver, Butler County, and Lawrence County. The telephone number for that would be 412-255-6700. And that concludes today's presentation. I'm certainly available to take any questions that you may have. I thank you for your attention this time, and now it's not raining.
Hi, I'm State Representative Matt Smith, and I'm partnering with Bethel Park to host a free paper shredding and recycling event on Saturday, August 18th from 10 a.m. to 1 p.m. in the parking lot of Independence Middle School. Independence is located at 2807 Bethel Church Road right here in Bethel Park. Consumer fraud and identity theft are a growing concern in our communities. To raise awareness and to promote prevention, I am hosting this event as a safe and secure way to destroy unneeded documents free of charge. The shredding occurs on site and the paper is later recycled. You can even watch while your documents are shredded if you choose. You can bring any papers containing personal information like credit card or bank statements, canceled checks, income tax and pension fund statements, as well as insurance information or medical records. At previously held shredding events, over 500 cars dropped off documents and saved over 10 tons of paper from area landfills. If you are interested and have additional questions, please call my office at 412-571-2169, and my staff would be happy to give you additional information. I look forward to seeing you at Independence Middle School on Saturday, August 18th. Hi, I'm State Representative Matt Smith, and I want to take this opportunity to thank all area veterans for your service to our nation, Commonwealth, and our Bethel Park community. It is a privilege for me to serve as your state representative, and I consider recognizing our area veterans and remembering the servicemen and women abroad and those brave soldiers no longer with us an honor and a responsibility. I believe it is important for all of us to recognize and express our gratitude for the tremendous sacrifices made by the few to keep all Americans safe on Veterans Day, on Memorial Day, but really 365 days a year. Thank you for all that you have done for this country, and may God continue to bless you and the United States of America.
Hey, you ready?
Of course I am.
What are you waiting for? I was waiting for you.
So we're gonna continue the company thing real quick.
Okay, places everyone. In a minute! Do I have to do everything myself?
You can't do it all by yourself.
I'd say that...
Sure I can.
No, he can't. And neither can I. So why don't you come on down to BPTV and help us make some of the great community programs you see on this station every day?
Yeah.
I mean, we can help you make your TV show ideas a reality.
It's pretty awesome.
So come on down. I mean, I am pretty good. But I'm sure I could use your help.
The American Legion honors our newest generation of warriors and veterans. Please join us in supporting and recognizing their unique contributions and needs. Go to legion.org/honor veterans to find out more.